It's time for the final 2024 episode of the real Crimes of Kurri Kurri. Kurri Kurri Local Court sat on the 10th of December 2024. I will do this episode in two parts. First, the traffic ones, and the second part will be the assault, drugs, and a Commonwealth offence. It's a hot day on this day, so the fans in the courtroom are on top speed, meaning you're allowed to raise your voice at the magistrate to be heard, which could also be referred to as yelling at the magistrate. Knock it off, birds. Today there's the usual traffic offences and assaults, similar to the previous episodes, however it's just a different variation to the theme. And of course there's some new cases that got transferred to Cessnock Local Court for a hearing in 2025. They include another not displaying the P-plates, an assault with an AVO and a cross-application AVO, meaning the complainant and the defendant are both seeking AVOs against each other. And an unregistered animal. Couldn't quite catch what type of animal because of the noisy fans. The police aren't prosecuting in this one, rather it's the local council. The magistrate did take the time to explain that the defendant would be required to pay council's legal costs if they were found guilty at the hearing. I have no idea what the fine is for an unregistered animal, however I assume the council's legal costs will be in the thousands. Before I discuss the cases that were finalised on this day, just a reminder of why I think we should talk about them. Because most of the sentences given were for general deterrence, meaning the sentence is meant to deter us outside the courthouse from doing the offence. However, I would argue we need to know about the case to be deterred. Therefore, the case should be spoken about outside the courthouse. Let's start with the usual offence, that is, driving while suspended. The person got the attention of police because of something to do with their P-plates, where it was then discovered that they were suspended from driving. They got a conditional release order for 6 months with two conditions. They must not reoffend and they must return to court if required. No conviction was recorded. Then there was a mid-range drink driving. This person came to the attention of police in October 2024 because they were driving around at midnight without any headlights on. They blew .086 and had their licence suspended on the roadside. The court hears how the roadside loss of licence has had a heavy impact on the person, particularly regarding employment and with young children. The magistrate explains general deterrence is a significant factor in this sentence. That means for the rest of us out here. The inconvenience of suddenly not having the ability to drive yourself to work and drive your kids around could be a big deterrence to a lot of people, and therefore something to consider when a person decides to drink and drive. The person was fined $440, disqualified for 3 months, which is backdated to October, and will have an interlock for 12 months when they get their licence back, and a conviction was recorded. Next is a high range drink driving. The person had a few drinks and decided to drive to KFC at about 10:30 at night in mid-October 2024. There was a 10 to 15 minute wait on the order, so they were asked to move to the waiting bay. While waiting in the waiting bay, you guessed it, the person falls asleep. Police become involved where the person blows .162. The sentencing in this one is more of a deterrence for the actual person rather than a general deterrence like in the last case. This is because the person has similar offences in the past and the magistrate is attempting to give a sentence that specifically deters this particular person. The person's life circumstances are different to the previous case. They were fined $770, disqualified for 1 month, and will have an interlock for 12 months when they get their licence back. Staying with the traffic theme, the next offence was taking a conveyance without consent of an owner. It's section 154A of the Crimes Act, and it's commonly referred to as the joyriding offence. It's driving around in someone's car without their permission. The court hears a Nissan Patrol is discovered missing sometime on the 22nd or 23rd of November. The friends of the car owner commence a community-style investigation on social media, which leads them to a Nissan Patrol parked out the front of the defendant's house. Honestly, I think some people need to be deputised because of their ability to solve crimes via social media. Anyways, this Nissan Patrol has no plates and is covered in mud. Police become involved and question the defendant, who claims to have purchased the vehicle from a crackhead. Anyways, it turns out it's the missing patrol and police charge him. There's actually two charges. The first is the take conveyance and there's a backup charge. It's not uncommon to see a backup charge, which in this case is goods in custody. Basically having a stolen item in your possession. It's section 527C of the Crimes Act. And there's a higher penalty if the stolen item is a vehicle. Anyways, because of the circumstances, and in particular the fact that there's clearly been some joyriding because of the state of the muddy car, the prosecution chooses to charge the person with take conveyance and drop the backup charge. The person who's pled guilty was convicted and placed on a community corrections order for 18 months with 2 conditions. They must not re-offend and they must return to court if required. Plus, the magistrate warns the person about jail if he returns. Next case relates to traffic, however this time the charge is goods in custody. The person owns the vehicle they are driving. It's the trailer with the generator that the person is towing that's the centre of the legal problem. There's a few versions of how this stolen trailer with the generator are being towed by this person. The court first hears the person tells the police their friend hired the generator and they're just towing it for them. But then the story changes because the person then claims they met 2 guys in the bush who asked them to tow it for them. In my opinion, as soon as we hear the 2 guys in the bush, the magistrate switches up a gear. The magistrate decides not to work out what version to accept. Instead, they just focus on the fact that the stolen trailer and generator is hooked onto this person's car. Hence, the goods in custody charge. The person pleads guilty and is sentenced to a community corrections order for 12 months and 50 hours of community service. I think the general deterrence message for us outside the courthouse is to avoid legal situations that involve meeting 2 guys in the bush. Stay tuned. In part 2, I will discuss the rest of the cases which were finalised on this day in December at Kurri Local Court.